Welcome to Let's Just Talk. I'm your host, Hami. Today, we're joined by Dr. Wadie Said to unpack the relationship between Palestine and American law. In other words, we'll examine how Palestine has shaped American law over time. Dr. Said is a professor of law at the University of South Carolina School of Law, where he teaches courses in criminal law and procedure, human rights, immigration law, and counterterrorism. Dr. Said, welcome to Let's Just Talk.
Thank you for having me.
Of course. And to begin, we're going to give you 3 to 5 minutes to offer your insights on this issue and kind of like draw the context of our conversation for us.
Sure. So I think I became interested in the way kind of the issue of Palestine interacts with American law sort of elliptically, in that I would come to it via a look at various topics in the law. Specifically, I was looking a lot at how the United States employed law to prosecute people criminally they'd accused of terrorism or terrorism-related crimes. And, so Palestine would come up in various ways over a certain number of issues. Like I was looking at, there's a well-known, in the sort of terrorism context, there's a well-known law called the Ban on Providing Material Support to Foreign Terrorist Organizations, which has a kind of a disproportionate focus on Palestinian groups that the American government considers terrorist organizations. And this law has a host of kind of constitutional issues, or I think constitutional, in my view, they're constitutional defects that render it suspect, and in terms of how it's crafted and also in terms of how it's used as a tool. So I was very keen on studying that. I also studied cases involving the use of coerced confessions from abroad in American terrorism prosecutions. Again, the issue of Palestine has come up in cases like that. Further, as you mentioned, I teach immigration law. So Palestine, as a kind of a country that's not officially recognized by the United States as a country, has its own kind of stamp on immigration law in various ways that I also, kind of would kind of treat a little bit in my writings or in my talks, but not in such a direct or overt way. And what I started to see is I was touching on this issue in many different areas of the law, but not fully engaging with it. So I thought the time was right to begin a more kind of comprehensive study, a more focused study, a more holistic study that looks at the role Palestine has played in shaping law in the United States. And, in terms of, obviously there are many components, and I think the most obvious one of which is American foreign policy and how that affects domestic law, but also things such as the fact that Palestine is not a country that the United States recognized. So there isn't the same level of protection that there is for people from there in terms of, people who work on behalf of the Palestinian cause. They're not government officials who would enjoy a level of protection from lawsuits in the United States that officials of other countries would, as a kind of a sovereign immunity. It's also allowed the United States to shape its concept of terrorism as a non-state entity, or a non-state activity, I should say, as opposed to a state endeavor that exempts that.
And then when you speak of level of protection being enjoyed by those that the United States consider to be a country as opposed to Palestinians, if let's assume the U.S. government was to want to prosecute someone that they deem to be a threat in Palestine, how would that process work? Is there representation for those people? How can you just speak about the process in which it's occurs?
There are methods for prosecuting government officials. For example, there recently was a case involving a former Mexican security official who was prosecuted in Brooklyn, in federal court in Brooklyn, for basically taking large payoffs from drug cartels in Mexico. And there have been attempts over the years to prosecute individuals, to prosecute government officials from abroad. But that's a fraught exercise, right? That involves considerations of foreign policy. And I think in the Palestinian context, you don't even have that opportunity because there are no Palestinian government officials that the U.S. government recognizes as officials who would kind of enjoy a level of sort of sovereign immunity. It also means that any actions taken collectively, right, are going to be subject to a level of deference so, for example, one of the things you see is, in cases involving Palestine, any attempt to say that the Israeli government did something wrong or to use it as a defense is not going to meet with much success because they're representatives of a sovereign government, whereas Palestinians are not. So that's another thing really to bear in mind. This is not just the foreign policy nature, the fact that you're dealing with not a sovereign country as well. So that also intrigued me as to how that might shape the law.
Okay, and then how has the situation of Israel and Palestine influence American national security law, particularly in regards to counterterrorism?
Yeah, so I think what you see is actually, and this starts to take place in the era before the 9/11 attacks. So in 1996, that material support law was passed, and it banned the provision of what's called material support to foreign terrorist organizations. So let's leave what material support means aside for a second. But there's a list that's made up by the Secretary of State, where he now will designate organizations that are A, foreign, B, engage in terrorism,
Right.
and C, that terrorism threatens the national security or the national security of the United States or the security of United States nationals. And national security of the United States can mean or can include the foreign interest relations of the United States, or the foreign relations interest, of the United States.
Right.
So that's a finding that is not challengeable. So you or I couldn't go to court and say, well, the Secretary of State listed Group X as a terrorist organization, and we think it doesn't, we believe that Group X does not impact U.S. national security in its actions, so we think it should be delisted. That's not something that a court will ever get involved in.
And so once they're listed, how does that impact those groups?
So then you're not allowed to provide what is known as material support to them. And what that means is you can't give them money, okay? You can't act as an expert on their behalf, right? You couldn't say, hey, you're a violent group. I'd like to teach you how to be nonviolent. Okay. That would be material support, right? So even speech, expert assistance, clearly things like money and weapons are sort of top of the list.
It takes away the ability of advocacy groups to advocate in a sense.
Yes, especially in the nonviolent sense as well. Because the other thing it does is it's based on a theory that money is fungible. Okay? And so Congress, when it passed this law, basically agreed with the idea that if you give money to a group for charitable activity, and the group engages in undisputed charitable activity, that frees up money for the group to then use for weapons and violence. And that can be criminalized. But it's now taken a life of its own, where material support is not just money or weapons or things like that. It also could be things like speech. Like if I came to a representative of a group and said, hey, I want to teach you how according to international law, how you can advocate for yourself. That would be material support. So the role of Palestine in the material support law is that the kind of model terrorist organization that the government was looking at was that of the Hamas movement, the Islamic resistance movement, as it's known, in Palestine, which basically the American government and the Israeli government accused them of raising money through their charitable wing, right? And of course, that's, I think, a pretty contentious proposition, and I don't think it's necessarily true, but that's another story. And the idea was that terrorist groups, according to the U.S. government, are raising money in this kind of clandestine way. They're saying it's about charity, but in reality, it's about strengthening themselves and making themselves more popular, and also freeing up money for violence via this charitable facade. And so the paradigmatic model of the terrorist organization is the Hamas movement. So when the first list comes out in 1997 of foreign terrorist organizations, it's prominently featured are, I think, 6 or 7 Palestinian groups. So in the initial instance of this law and how it works and the groups that are listed as foreign terrorist organizations, Palestine plays a big role. And so one more thing is that it comes at a time where the United States is deeply invested in the idea of a peace process in the Middle East. So these are the groups these are the Palestinian groups, and there was one Israeli group that were perceived to be as opposed to this peace process. Yeah.
And so to pivot a little bit to the area of constitutional law and First Amendment, how has pro-Palestinian activism in the U.S., such as the BDSM movement, affected American law overall?
So that's a very good question, because currently what we're seeing in the courts is there is a slowly becoming more constant kind of thrum of litigation involving states that have passed anti-boycott laws with a specific target of groups or individuals who would attempt to boycott dealings with the Israeli, the Israeli government, Israeli academia, Israeli businesses, etc. And they're being targeted by state governments who say that, if you want to have contract with the state in any way, shape, or form, you have to disavow your right to boycott, which has clear First Amendment implications. And the question really is, and it's interesting because it's been framed in a series of recent court cases, the question is, how much does this impact the First Amendment? So, I think at sort of, an initial outward blush, it seems patently obvious that if the government is saying you can't deal with us based on your political views that you have to kind of abstain from, that seems to clearly implicate the First Amendment, the sort of hallmark freedom or constitutional provision of what it means to be an American, in the kind of ideal rendering of America and its status as a country, and sort of what it thinks positively about itself.
Do these hallmark cases that are related to Palestine have any significant impact on American citizens? That they should be concerned with, in a sense?
Well, So I think when you talk about the material support cases, there's certainly questions about freedom of belief, freedom of association, but it's a little bit kind of harder to get at that because of this idea of a group that's been listed as a foreign terrorist organization. So there's that element of, being outside of the United States that impacts the discussion and makes it harder to have a more clear-headed discussion because it brings up issues of national security, which are normally not things you discuss in a courtroom. With the issue of the boycott, with the issue of the sort of anti-BDS laws or anti-boycott laws, there it's kind of very squarely within what the First Amendment says you can't do, which is have the government tell you what your speech should be or what your association should be or what your, your kind of expressive content should be. And it's interesting because the most recent kind of statement on the matter was from a federal appeals court covering parts of the Midwest and the sort of central South that basically found Arkansas's anti-boycott law to be constitutional and not to infringe on freedom of speech. And it all broke down in a way that kind of, or the opinion of the court really broke down on making a series of assumptions that I don't think jibe with how the law should be read.
Okay, which are?
So it made an assumption about whether or not, freedom of speech or freedom of expression was really being covered. It basically, the court just said this is dealing with business activity.
Okay.
But the way the law is written,
it's not.
The way the law is written is broad enough to encompass more than just business activity. But the majority of the court there, which to be fair is a very conservative court, the majority of the court there basically kind of assumed the validity of the law and that it was dealing only with these kind of business activities and that it didn't really have a speech or expressive content, which I don't think was the right reading. But
and then to pivot a little bit, there is a lot of movements such as like the end apartheid movement when it comes to Israel and Palestine, and movements that are designed to talk about Israeli official treatments of Palestinians in different parts of the region. How has these movements or like the treatment of Palestinians impacted American law in relation to like international law and how Palestinians are treated?
Well, I think you're seeing there's a huge. So I think that's a kind of a more. I think as a question, in terms of what's the difference between American law and international law, you're seeing an effort by Palestinian organizations, NGOs, the Palestinian Authority to try and bring a prosecution against Israeli officials for their various actions, their kind of for accusing them of war crimes in the international criminal court sphere, which is an incredibly politicized endeavor, right? And the United States has been squarely against this, and has been, and the investigation itself has been held up innumerable times and for a great length because of the fact that you have larger nation states that, like the United States, that don't want to see the possibility of their officials being brought before the international court, which the United States and also Israel have not. They're not signatories to the ICC treaty. Yes, so that's a kind of an international law hot potato, which, and you're seeing it in the context of Ukraine now, where you saw that the Russian president, Vladimir Putin, there's been an arrest warrant issued by the International Criminal Court, which, it's the likelihood that what's that?
That seems more symbolic than anything else.
It's symbolic, but also, for people from, who have a more who look at these issues from the perspective of the Arab world, the developing world, Africa and Asia, that it's an extremely cynical exercise because you had the international, that's a whole other, by the way, area that I won't be talking about in great depth today, because you have the issue of the fact that before Putin, no one has been brought before the ICC or, indicted before the ICC who wasn't from the continent of Africa. So there's this kind of racial angle, racial and political angle, which is it's only these kind of less influential, poorer African countries against whom ICC prosecution is wielded.
And then that also brings in the question of whose pain really matters or whose tragedy really matters to come before the ICC and so on. And to wrap it up, as you mentioned a couple of times, Palestinians in the American context are not, like Palestine is not considered a country. So a lot of them, like when it comes to refugee status, immigration status, how does that work? How has it impacted American law? And then if Palestinians, where do Palestinians go to get justice or to seek justice? If
you have to tell me that one.
You're the expert.
I don't know.
It seems you don't have an answer for that. Right?
No. So I think with respect to immigration law and the issue of refugees and things like that, so Palestinians are often stateless, right? And that can have a real impact on when this country wants to deport them, right? When it says that they're here in violation of immigration law, where do they go? And and it could end up in, there are situations now, more and more cases have been kind of more and more decisions have been issued involving situations where individuals are held for a long time in immigration detention, where there's no reasonable likelihood of them being deported.
Right.
And the Supreme Court has it's very interesting. There was a case that the Supreme Court decided in 2001. It was the last decision the Supreme Court issued before the 9/11 attacks, where it said that people held in immigration detention more than 6 months with no reasonable likelihood of them being deported, need to be released unless there's they pose some special particularized threat. So Palestinians often deal with the scenario where they've been detained longer than 6 months, and there's no real likelihood that they're going to be deported. And that's in cases not just where they've been residents of the West Bank and Gaza, but where they came to this country and they had Israeli citizenship or Jordanian citizenship, or they were residents of Lebanon or Syria, where they didn't have citizenship but they had Palestinian refugee status. And all the Egypt, all these countries that don't want to cooperate for their own reasons with accepting Palestinians sort of back when they're being deported from this country, which then creates all sorts of problems here for them, where they end up being detained for much longer than 6 months with no reasonable likelihood that they'll ever be removed from the United States.
Dr. Said, it's been great having you on Let's Just Talk.
Thank you.
We look forward to continuing these conversations with you.
Thank
you for being here.